Right, so we saw in Shogun Finance that courts will not be very quick to take pity on innocent parties and adjust concepts to specific context. So Shogun Finance is a good illustration of the importance of concept, in this case, concept of legal property right that Shogun Finance as a financier held. Another wider point that I want to finish on this section, context versus concept, is that we have to be very careful when we say, as Baroness Hale did in the quote at the start of the handout, that context is everything. Okay? Judges decide cases, resolve disputes, not based on context, but by taking into account the concepts which will flow from the bargain that the parties have concluded, and some rules that will apply, such as property law rules, that will apply between the parties. And we'll see in this term in particular very well how those concepts are employed and how commercial parties' obligations are governed by both contract and rules contained in common law cases. Okay. Any questions following the break? Okay. So let's move on to discussion of the basic concepts. And I'd like to talk about two. One is property rights, and the other one is the concept of bailment. And there will be other concepts throughout the course that we'll learn in greater detail, but those you ought to be able to relate to based on what you've done in the past, in particular property rights. So I'd like to orientate our discussion by talking first about significance of property rights. Why are property rights important? You have no doubt studied in Property 1 and 2, you have studied how property rights, ownership of land is created, how it's held, how it can be perhaps passed, what the trust is, and so on. But the question now is, and hugely important in commercial law, is why do property rights matter? What's so special about them? And why can they make such a big difference to a dispute? So first of all, what's the main difference between property rights and personal rights? So what's the difference between personal rights and property rights? Yep.
Well, for example, if you've got a claim against a person in persona, you can only, it's sort of like your status is one of a normal creditor, whereas if you have a proprietary right to something that another person holds, then your right attaches to that very property, and then any proceeds from that property.
Mm-hmm. So there is the importance of an asset, and so there are a number of points that will flow from there, and we'll talk about them, but we had another hand over there, two hands in fact.
Rights are transferable, but personal rights are not.
No, because in Don King Productions, it was made clear that you can hold a personal right on trust for someone else.
Some personal rights can be indeed transferred, and you will talk about assignability. For some reason it's called assignability rather than transferability of personal rights, particularly rights to payment. So if you agree to buy a laptop from me and you pay me £1 for it, I have a right that you pay me £1. That's a personal right. It's not a property right, it's a personal right. So if I have a right against you, and I really don't want to be dealing with you because I'm here and you're there, and I just don't want to have the hassle, then I can assign my right to somebody else. But not all personal rights can be assigned. And you will talk about assignability, assignment, at the very start of term 2. So property rights do relate to an asset, and they enable a person to exercise a set of rights over that asset. But it's not about what the person can do in relation to that asset, it's about who they can exclude. I saw another hand earlier on about the distinction personal and property rights. Yeah?
Property rights can bind third parties, whereas property rights can't.
Absolutely, and I think that follows on from the discussion we've just had. It's basic distinction between property rights and personal rights is that property rights do relate to an asset. They enable a person to exclude third parties from using the asset, possessing the asset, selling the asset. And if a third party comes and interferes with that asset, for example, takes possession of it, or purports to sell it, like we just saw in Shogun Finance when the rogue purports to sell the car that they did not own, then the real owner does have a right against a third party. And it manifests itself in a number of contexts, and one, which you may well not have thought about in great detail yet, is the context of insolvency. So, before we do that, let's just do a little lead-in. So, if I sell a laptop to you for, let's make it more realistic, for £500, okay? I've got a right that you pay me the price of £500. You take possession of my laptop. It's yours, perhaps, if we agree so. And I have a right that you pay me £500, but you decide not to pay. For some reasons, all sorts of reasons, but you decide not to pay. What are my rights against you? You're the law students in third year. What would you advise me? Imagine I know nothing about law. What can I do?
Contractual.
Okay, you tell me contractual. I'm a lay person. I know really nothing about law.
Well, there was a meeting of minds,
Yeah.
and you were to give over the money, and then the other party was to give the computer, and you have not, the person who has failed to pay the money for the computer has not honoured their side of the bargain.
Well, that's all very true, but what can I do? Because what you're telling me is that it's important once our minds have met to uphold the primary rights. So it's John Finnis, importance of primary rights, of course, but it doesn't help me. I want the £500. What
Take
do I
the
do?
person to court.
Take to court, right? Take to court.
Sale of Goods Act, perhaps, might help.
Might help. Let's assume the court has ruled in my favour. They said, indeed, the person who bought my laptop now owes me £500, so they must pay. What happens next? That's just a ruling of the court. What happens next?
Personal right. It's a personal right.
It is a personal right. Just because it's a personal right doesn't mean it's non-existent or existent. What can I do with it? What do I do to get my £500?
You have to go to another court once you have a ruling from the initial court saying you have a right to get this money from that person. Then you go to another court, I believe, county court, and then they essentially enforce the retrieving the money.
There's going to be an enforcement procedure, so not necessarily a full court proceedings. And it's a slightly unfair question on my part because it's to do with civil procedure, which I have every right not to know. But the point is that once the court says, yes, you must pay £500, this then is useless to me unless the person who owes me the money actually pays. If they still refuse to pay, you can enforce that judgment. So there will be another procedure. Now let's assume this procedure goes through and the person who doesn't pay will have to pay somehow. How do they pay? They don't presumably put a gun to your head and say, well, you must pay. They don't do that. So how do you make someone pay? You can put them in prison, can you?
You can apply to the court to get essentially what would be akin to proprietary rights. So get the court to force the debtor to sell some of their possessions to pay for the money if they're going insolvent or something.
It's a good thinking. You don't necessarily ask the debtor to do that because they might just not do it again. You had another.
I was just going to say the assets can be liquidated.
Right.
But by force, I mean,
That's right. So you're talking both about the same situation, which is an enforcement officer seizes the assets of the debtor, sells them, and uses the proceeds to pay the creditors, including me, including the £500. Okay? So it's the enforcement officer who comes in, and for companies, the enforcement officer will be called liquidator, hence liquidation is used as a term for seizing the assets and selling them, and using the proceeds to pay the creditors. Now, it's all very well where the debtor only owes money to me and nobody else. But it might be that they owe money not just to me, but also to a number of other people. So I'm only one of many creditors who ask for £500. And it might be that all the assets of this person consists of this £500 worth of laptop. They have nothing else, maybe a toothbrush and a pair of shoes, and that's it. I don't know, close. But the point is that the assets, all the assets of the debtor, might be of much smaller value than the claims of all the creditors. So what happens then?
On secured creditors, it's pari passu basis.
What is a pari passu
Well,
basis?
it used to be first come, first served in terms of what is remaining from the pool of money that the person who's gone insolvent has, and what the creditors can get to. But now it's sort of, you have the creditors and then they divvy up the amount that's left per creditor, pari passu, I believe so. But if you have some sort of proprietary right, like as a trustee or a beneficiary, then you'll take precedence, you'll have priority.
Mm-hmm. So first of all, when your assets are much smaller than the claims of the creditors, that is a case of bankruptcy or insolvency. Bankruptcy for individuals, insolvency for companies. And it could be a question of insufficiency of assets. It could be cash flow insolvency. So maybe you are already, if you're a company, you're producing stuff, you're being owed money by other people, but they don't pay. Then you have a cash flow problem, and that also leads to insolvency. So the problem is common, which is that when the creditors demand payment and the enforcement officer liquidator comes in, sells the assets, there aren't enough of them to pay the claims. Now, in insolvency, it has always been the case that the enforcement officer paid proportionately to the amount of claims owed to the creditors. So if the assets I've got a diagram actually, it might be a bit more interesting. So, does it look familiar? Yeah. So, if someone has got £600,000 worth of assets, and all creditors B, C, D, E are each owed £200,000, liquidator comes in of A, assuming A is a company, or a trustee in bankruptcy if it's an individual, and seizes all the assets that belong to the individual, company or a person, and uses those assets to sell them or to generate other income. It's possible to, if you have land that's leased, you can continue leasing it and generate income that way. But they seize all the assets. And if they all have personal claim, the distribution of money to all the creditors is pari passu in proportion to what they're owed. So if each is owed 200,000, assets are 600,000, math is very simple. Each creditor is owed 120,000. That's actually not too bad. This example is hugely unrealistic because in real life, when it comes to bankruptcy or insolvency, the creditors hardly ever get anything close to this sum. It's usually much, much less. But you rightly pointed out that if one of the creditors has more than a personal right, not just a right to be paid, but a property right in an asset that is in the hands of the individual or the company, then they can assert their property right against the liquidator or trustee in bankruptcy. They simply say that asset is mine and does not form part of the distribution estate, insolvency estate. So what's the relevance for this creditor? Well, assuming B has a property right in the asset worth £200,000, B simply gets the asset. What about C, D, E, and F? What do they get? How much do they get? Well,
So the secured creditor has taken 200,000.
yep.
And the debtor has 400,000. So the secured creditor will take 200,000, and then 200,000 divided by 4, 50,000 each.
Mm-hmm. So I think that must be right.
Oh, yeah, sorry, so I didn't see the 600.
So the important point about property rights is their immense value in insolvency. If you have a property right in an asset of another person who happens to be in possession or who claims rights to that asset, and they go insolvent, if you can prove that you have a property right, then generally speaking, you have a right to have that asset set aside. The plain example is when you are actually the owner, when someone else is simply in possession. Again, Shogun Finance. The rogue was not an owner, they only had the possession. Shogun Finance had the legal property right, ownership to the car. They had the right, in case the rogue was still there and in case they went insolvent, they could have simply taken the car in satisfaction of the claim owed to them. Another example of property rights, we mentioned trusts. Rights of a trustee are legal property rights. So in case the trustee has to assert a right against somebody else except the beneficiary, then they will have a right to have an asset set aside. But it's more common to talk about the insolvency of the trustee himself or herself or himself. And then the question is, does the beneficiary in a trust who has only an equitable property right, does the beneficiary have a right against the trustee when they have gone insolvent? They do, because they have an equitable property right, and it's not as strong as legal property right, but it's sufficiently strong in insolvency, and it gives you the same protection as the legal property right in insolvency. There are other rights, property rights that will be important, security rights. So rights by the creditors, lenders who advance money and they're worried about not being paid, lenders will bargain, contract for a specific right, specific security right in an asset. And those rights will be of various kinds, legal rights, legal security rights, or equitable rights. All of them will give the lender, who will become a secured creditor, a secured lender, a right to have the asset set aside. There will be an exception, a floating charge, which we'll talk about later on, which doesn't procedurally work in the same way, but it still provides a strong position to the secured creditor. Okay, any questions? Happy with that? All right. So the illustration, a good illustration of the importance of property rights in insolvency is the case of Rewait. So this case is a sale of goods case, so it's handy to flag it up now before we discuss sale of goods stuff later. And in this case, we had 1,000 tons of wheat shipped on a ship called Challenger. The wheat was sold to Waite, and Waite then sold that wheat, part of it, 500 tons, to a third party, H&B. All these sales took place whilst the wheat was on the ship and still floating somewhere on high seas. The beauty of sale of goods is that it can be concluded by virtue of consent between the parties, and property rights and obligations between parties can pass or be created. But in order to do so, certain conditions must be fulfilled. So what happened in Rewait? Waite sold 500 tons to H&B. H&B promptly paid. The wheat arrived to Waite. They received 530 tons of it. In the meantime, other portions of wheat got distributed. But then the Waite company had some financial difficulties. And whilst the wheat was with them, on the ship still, the creditors of Waite managed to get a liquidator appointed. So Waite became insolvent. The question then became whether H&B, who bought and paid for the wheat on that ship, they bought 500 tons of it out of 530, whether they could claim a property right in the wheat in the hands of the liquidator or not.
Doesn't it depend on whether the wheat was apportioned, the specific amount of wheat? Or so in Regold Corp, I think there's sort of a similar situation where they're selling on some gold, and if the gold is put aside at the point of deciding that there's going to be a sale, then from then on, whoever holds it, there's a beneficial interest by the person for whom gold is destined to get it.
That's right. So the question was did H&B have a property right in the wheat? Problem is, 500 tons was the agreed amount of wheat to be bought out of 530. It's not specific which 500. So,
but then you look at Reed Lehman and the trade cases. I suppose this is in 1927. But if you look at the trust cases to do with shares, if you have sort of a general idea, so type of the thing, the amount of the thing, at the end of the day, how much of it is good, what's it going to look like, perhaps it's not hard and fast rules in terms of, does this 500 tons have to be put in a different room?
There are some hard and fast rules on this occasion. But so in sale of goods, and we'll talk about the details, what's necessary for property to pass, and we'll talk about the case of Gold Corp as well. But it's necessary to know what specific thing you're buying, and only then H&B, as the buyer of the wheat, can acquire property rights in that wheat. Otherwise, it just doesn't. The property rights do not pass. The consequence is that H&B do not have a property right against the liquidator in the wheat. Can they still claim the price from the liquidator? Can they say, well, we've paid the price, we didn't get our goods, can we get our money back, please? Can they do that? They will not have got from this contract what they bargained for. So, of course, yes, they can sue for price or for damages. But the important point here is that it's only a personal claim, not a property claim. And given that there are other creditors and Waite is in insolvency, this will not be very useful, practically not very useful. Interesting point about re-Waite is that it was argued whether, because Waite is under a duty to pass 500 tons of wheat to H&B under the contract, whether that duty is sufficient to create a proprietary right in favour of H&B. So the bargain said sell 500 tons of wheat. They were already under a contractual duty to sell 500 tons. So that might look like very much like a duty of the trustee to hold specific assets on trust for the beneficiary. So you might ask whether that contract might create an equitable property right. So not a legal one, an equitable one, which will still be good in insolvency. Remember, it's still property right, equitable or legal, still strong in insolvency. But the court held that no equitable property right could arise in a sale of goods. Why?
No segregation.
That's right. The property is still not clear.
But now, with the shares cases, it might perhaps be different?
Well, I don't think so, because we are looking at goods. And so London Wine as well, we could argue about those. But and in any case, now, under the Sale of Goods Act, we'll look at specific provisions of that Act which do facilitate passage of property in those sort of scenarios where ship is shipped on a ship and sold ex bulk from the ship. So there are specific provisions that enable the buyers in specific cases to acquire property rights. That's Section 20A of the Sale of Goods Act. But we'll look at that later. Another reason why property rights are so important is the nature of claims that a holder of a property right might be able to bring. And a good example is the Ali Akman case. So in the case, we had a sale of coil on a ship. The sale was C&F, and it's a description of trade terms, which I'll refer to in a minute. And in the process of shipping on Ali Akman, by Ali Akman, who was the shipper, the coil was improperly stowed and it became useless. It was damaged. So L&S, Lee and Sullivan, bought the coil, which arrived and it was damaged. Nonetheless, the seller asked for a price to be paid. Well, the buyer acquires damaged goods, so they don't want to pay. But the terms of the contract entered into, C&F, were such that the seller had a right to the price even if the goods arrived damaged. That means that the insurance of the goods, the risk of any damage to the goods was on the buyer. Okay? But also under this contract, there was a provision that until the buyer pays the price, the seller, K&M, are the owners of the coil. Okay? So two things to bear in mind. So the buyer is asked to pay the price to the seller, K&M. They are contractually obliged to do so, and the court will enforce that bargain. What's their other best option? Well, the shipper, Ali Akman, was negligent in storing the coil. So L&S could try, and they have tried, to sue the shipper, Ali Akman, for improper storage, for negligence, and recover damages. Can they do so?
Yes, because they failed to take reasonable care in the storage of the wire.
So Ali Akman did indeed fail to take reasonable care, but towards whom? That's the question.
So you said that there's provision that property didn't pass to the buyer unless they paid for it, so technically it's not their property, it's like when they receive it.
Absolutely right. So the question was whether LNS or K&M had the right, the standing to sue in negligence. And in order to do that, you have to have a property right in the asset. Otherwise, you just have a contractual right to the coil and not property right.
But in CNR and Norsk Shipping, which is a Canadian case, you can sometimes bring in a so-called third party in the pure economic loss cases, if they can be sort of likened to joint venturers, which perhaps these two parties could be.
Well, it wasn't the case here, and interestingly, we're not entirely sure why K&M, because what LNS could have done is ask K&M to sue on their behalf. That's a simple business deal. You don't need law for that. But presumably K&M refused. They must have refused because they had to resort to this action against Ali Akman. So K&M only had the right as the property right holder to sue in negligence and not LNS. LNS did try to argue that they had equitable property right, even if they did not have the legal property right. But that argument was rejected by the court, relying on reweight, the case we have just seen, and saying this is a sale of goods. A duty to pass goods does not give rise to, under a sale of goods contract, to equitable property right. Therefore, LNS had no property in the goods they have agreed to buy, and they were obliged to pay the price to the seller, even though they received damaged goods. Okay? Any questions? Okay. So we talked about the proprietary context, why property rights matter for this third-party effect, in what ways property rights can be enforced against third parties. One final point, before we go to Helen Howlett, one final point on the Ali Akman, because it's just quite interesting. I mentioned that K&M, as the holder of legal property right, as the owner of the coil, were the only ones capable of suing the shipper for the damage. Now, in some cases, clever sellers might use that to their advantage, because the seller agrees to sell to the buyer, in this case LNS, and they have a right to pay the price, but they are also the only party able to sue the shipper for negligence. So there are cases, Sanix Ace, which is on the handout, is an example of this case, and an exact converse of Ali Akman, where the seller, under the contract, had a right to be paid, and it's a contractual right which will be enforced, but they also had a right to sue in negligence. And the court said, just because they have a right to be paid price for the goods, if they are the owner, they have legal property right, they still have a right to sue in negligence for the loss, for the damage to their goods. So it can work both ways. I've put the case Sanix Ace on Moodle, not because it's compulsory reading, but because it's, if you do want to read it, it's quite hard to access because it's in Lloyd's reports. So it's there for your convenience.
So once the buyer has actually paid the money, has the seller then no longer got the right to sue?
No, that's exactly, so they still do.
Still do.
So even
after
if,
the money's changed?
that's right. Because what you're looking at in tort of negligence is who's got the property in the asset and whether it has been damaged.
So at the time of damage they did. So.
Yeah.
So either one could sue?
Only the person who holds property right.
So in this case, the LNS hadn't yet paid.
LNS haven't yet paid, but they will be obliged to pay.
But they undertook to pay, isn't that enough?
It is enough. That's exactly why it is enough. but they get damaged goods, the question is whether they can sue in negligence.
So they undertook to pay, therefore they have a proprietary interest in the goods that they undertook to
No,
pay.
no. Right to obligation to pay has nothing to do with the rights in goods that you're acquiring. So I think I'm glad you said that, but we do have to keep those two things separate. Obligation to pay for goods under contract and whether or not you acquire property rights in them.
So in Salix 8, have they paid and then the damage happened? Or did the damage happen before?
It happened in transport. Before the claim was brought before the court, the seller already was paid. So you could argue, and that was the exact argument, that the seller did not suffer any damage because they were paid. So I hope it shows those cases illustrate the importance of holding a property right in asset. It gives you claims against liquidator or trustee in bankruptcy, in insolvency, priority, if you like, but better still say it enables you to have the asset set aside from a pool of assets and you can have a right to it irrespective of any other creditor. Okay, insolvency. Second, property rights are important for suing in negligence or conversion as well, in tort in general, for damage to the goods. Okay? Now, property rights also play a role in contractual aspects and the question of passage of risk. And a good illustration is the Healy and Howlett case, where we had a... let me put the slide on. It might be easier to talk. So in Healy and Howlett, we have a seller, Healy, who sells fish, mackerel, to a number of customers from Ireland to England. Howlett is based in England. And the fish has to be shipped, but before it can be loaded onto a ship, it has to be loaded onto a train. So Healy loads the fish onto the train, and it tells the railway official, gives instructions how the fish is to be distributed between the buyers in England. They send a large number of boxes to their destination, to the point to Holyhead. Among the customers, Howlett is only to receive 20 boxes of the mackerel. And Howlett contracted with Healy, stipulating that the mackerel has to be bright, hard and bright mackerel. That's how it was described in the contract. Unfortunately, the shipping doesn't go quite as according to plan because the train is delayed. They miss the boat. They have to get onto another boat, and all the 190 boxes are loaded onto the later boat. By the time they arrive in England, the fish is no longer hard and bright, and Howlett doesn't want it. So Howlett doesn't want the fish and doesn't want to pay for the goods because that's not what they agreed in the contract. Healy argues, first of all, that they did send an invoice to Howlett which included a term that the fish is at the risk of the buyer after putting the fish on the rail. So that statement was included after the contract was concluded between the parties. So, from contract law, do you think that statement is part of the contract or not? If it was included in an invoice after the contract was concluded? It's a term. No, it's not. It's not part of the contract. It does not govern the relationship between the parties. So, nonetheless, Healy argues that by sending all the boxes, putting them on the rail, they have discharged their obligation, contractual obligation to deliver. Because all they are required under the contract to do is to deliver hard and bright mackerel. Well, when it was loaded onto the train, it was hard and bright. Delivery fulfilled. But Howlett's counsel countered, saying, well, that wasn't the point, the relevant point where you should take into account discharge of the obligations. Because when the fish was loaded, the 190 boxes, we did not know which of those 190 boxes would become Howlett's. So there's again a question of, we don't know which
Segregation?
segregation, right. So the question of whether Howlett had property in the fish that was being shipped or not.
Is this before the Sale of Goods Act? Because I think that the Sale of Goods Act changed that.
No, so this is under the old Sale of Goods Act, 1893, so where the rules were the same. Now, the question is whether the party who receives goods that are damaged or who's asked to comply with obligations when the other party has not fulfilled those obligations, whether they are still obliged to perform them or not. That's a question of who bears the risk when something goes wrong. In this case, the goods arriving damaged to the buyer. If contractually the buyer was obliged to take them, no, because it was the contract stipulated the state of the fish. So the question was who bears the risk in this case of the other party not fulfilling. That's all.
Could you not take the sort of Denning approach and take the correspondence as a whole and then fuse the two documents to make what is the actual contract?
Well, you could, but that's not what the court decided. So of course you could argue on this basis. The question was whether Howlett had to bear the risk of the fish going off by the time it arrived, and whether they were liable to pay the price. And that, in turn, depended on the property passing to Howlett, or the point of property passing. If property passed to Howlett when the fish was bright and still fresh, then at that point also the risk of anything later happening to that fish passed to Howlett. So if fish was hard and bright to start with, property passed, if property passed, then also risk would have passed. However, in this case, because a large bulk was loaded onto the train and did not get segregated until it pretty much reached the destination, by which point the fish was already off, it was only then that property could have passed, at no earlier point, and it was only then that also the risk of any damage would have passed to Howlett. Before that point, the risk was, of course, on the other contractual party, the seller. The risk of the fish going off was on Healy until it was passed to Howlett.
Is there not a statutory circumvention of this in the New Sale of Goods Act?
In the New Sale of Goods, Section 20 says that risk passes when property passes as a default rule, but parties can agree otherwise.
Okay, all right, thank you.
Okay, everyone happy? So we'll see that property rights are hugely important, and they play a role both in third-party context but also contractually. And I would like you to bear those points in mind when you, throughout the term, but also the entire year, you come to discuss problem questions, but also essays, when you need to reflect on the importance of property right. Very often you will have, for example, a problem question with an insolvency context, and the question, the thing that you need to figure out is, well, if it's an insolvency context, then probably there's going to be a question of who's got a personal right, who's got a property right, how do I establish who has property right, and this is what we'll talk about throughout the term 1. But there will also be contractual aspects, such as the question of risk. When one party to the bargain does not fulfill their obligations, the other one does, and then the question is, can we ask the courts to enforce that bargain or not? Who bears the risk? Again, that question might appear, and the importance of property rights it's something that I'd like you to remember then. Okay? So finally, the last concept that I'd like you to bear in mind before we part is a form of rights relationship that is neither property nor contract. And you might have come across bailments in your studies so far, but you might not have yet.
Christie's, there's a case of Christie's to do with Christie's.
Well, there is one. Yeah. Have you discussed bailments in? I don't think that it was discussed in greater detail. So, bailment is, simply put, a legal relationship between two parties where a physical asset, goods, is passed to another without the first party, whom we shall call bailor, losing ownership. So bailor still remains the owner of the goods, whilst another party, another person, holds actual possession.
Is it like a bare trust in the favour of the settlor?
No, because then the settlor does not have a right to possession, necessarily.
But the settlor can set up the trust in their favour.
They can. But so a settlor can, if we're talking about the trust of physical assets, goods, then the settlor will be a beneficiary, and then there is a question of whether, as the beneficiary, you have a right to possess. No. You need to think about cases. You don't need to worry about those here, but if you are interested, MCC proceeds or Shell UK are the cases that you need to look at in trust context.
Yeah, I was just wondering, maybe the reversionary interest could be equivalent to Saunders and Vautier.
You don't need Saunders and Vautier. So in bailment, the bailor is still holder of legal property right. They don't lose possession, they don't lose the right to the asset just because they've parted with possession. Simple example, storage. When you have too much stuff in your house and you need to give them to storage, you conclude a contract of storage with a third party, and they will hold possession of your stuff for you. Now, during that time, a number of things might happen. I will need 2 minutes, and I shall finish. When the goods are in possession, a third-party wrongdoer might come and interfere, either destroy, damage, or steal those goods from the person in actual possession. And the question is, who has a right of conversion against this third party, or right to sue in negligence? And of course, the person who is the owner did not have actual possession. They might be able to sue as the owner, but the important point, sometimes quite efficient, if the bailee, as the person who had no ownership, no property right, could have a right to sue in tort. And so the case of Wingfield tells us that the bailee, even though they only had actual possession of the goods, have a right to sue a third-party wrongdoer in tort. So possession is a concept which is significant in commercial law, because it will confer certain rights on the person who has actual possession, and you might link it to the situation of a much wider context that, as against third party, bailee has a better right than the third party wrongdoer, better possessory right. And another aspect of bailment is that sometimes goods are carried on ship from one place to another, and sometimes a number of ships must be used. So when the goods are loaded onto a ship, the owner parts with possession of the goods, but then the person who receives possession, bailee, will have to load them onto yet another ship. So they will part with the possession. Of course, there is not a contract between sub-bailee and bailor. There is a contract between the parties who transfer possession to one another. So bailor bailee and bailee sub-bailee. But what if there is an improper handling of the goods by this third party? No contract, in theory no claim, but because it is a bailment, the courts have held in the Pioneer container case that the bailor still is owed a duty by a third party, even though there's no contract here. So it's a, if you like, breach of privity, very loosely said. The sub-bailee owes a duty to the bailor to handle goods properly, and if they're not, then the bailor has a right to sue sub-bailee for negligence, for example. Because the underlying point here is that a person who holds possession for another undertakes responsibility for looking after this possession, for looking after those goods. So by undertaking the responsibility to look after those goods, the law implies that there is a right on the owner to sue for negligence for not taking the right duty of care.
Why not just call it conversion?
Well, you could, but conversion, negligence covers slightly, it's just a different tool. It will cover not taking care, whereas conversion will cover interference, right? Yeah. But, yeah.
Linguistic, sort of.
Well, it's a legal because there are different concepts, but they respond to different things. Yeah.
So does duty of care come into it because there's a contract between bailee and sub-bailee?
There is a contract between bailee and sub-bailee, so there is a contract there.
Is that where the duty of care comes from, the idea?
From bailment. So it will come. So the sub-bailee will owe a duty of care to the bailor because there is a relationship of bailment, of looking after another person's possession. That's all there is.
So under bailment...
Sorry, I had another question just behind.
Yeah. Sorry, so can the bailee sue the sub-bailee if it comes, if they
So bailee have passed possession to the sub-bailee. So sub-bailee looks after.
Okay.
Yeah. So sub-bailee could also sue the sub-bailee. That's possible, and that would likely be contractual because there will be a contract between them. But the difficult question is whether a third party, which is third party to this contract, could sue the sub-bailee for not taking care of the goods. Does this make sense? Sorry, we had another.
No, actually that clears it up for me. I was just going to ask, so under bailment, anyone with actual possession can sue regarding the property, the Wingfield, and the bailor can sue whoever, the Pioneer container.
Right, so the bailor can sue the sub-bailee. The bailor, there will be restrictions on who the bailor could sue. We're not discussing them in detail, because in some cases the only person with right to sue will be a person with actual possession. But it's not a problematic point.
What kind of anomalies would those be?
Right, so there will be forms of pledge, for example, security right, which we'll discuss later on, where the person who has possession is actually secured creditor. So they hold, if you like, the asset hostage until they get paid their money back, the loan.
It's a more permanent form of bailment.
It's a different form of bailment.
We'll go over it later.
Yes, yes.
Thank you.
Yep. Any other questions? I'm sorry I have overrun. I will try to better manage. I'm delighted to know that there are so many questions on the floor. I really hope that it was useful to you. If not, if anybody feels this is not quite what I expected, let me know. I'd like to know that too. And I'll try to manage it in a different way that's suitable to you guys. So, okay, thanks so much. Thank you. Thanks.
Or secondary right, like damages. Yeah. But in a solvency scenario, all secondary rights that you will have will, if they are damages, if they're just right to damages, they will just refer to So not so what you want is to claim that you have a property right. And if you do have a property right, for example, a security right, some of those rights might give you a secondary right. But in a sense, we don't tend to talk about secondary rights because what's important is that there is a strong property right. That's what gives you the right to sex.
Okay, thank you. Lauren, not really sure where to turn it in Jakarta, any idea?
I suggest
Some people lost and found, but
I suggest a search section.
what? And it's the same on the other side.